let's just dive right into this explainer, guys, because what we are talking about today is literally a catastrophic financial mistake, and it is happening at kitchen tables all over the country. So if you're an adult child and your parents own a home, you need to pay very, very close attention to this. Because every single day, well-meaning parents are accidentally setting these massive financial traps that will absolutely decimate their children's inheritance.
I want to put the house in your name now, so you don't have to deal with probate when I'm gone. You know, this exact sentence was spoken out of pure love by a New Jersey mother named Linda to her daughter Diane back in 2021, and it triggered an absolute nightmare. Linda worked as a school secretary for 33 years. She saved, she sacrificed, and she bought this little home in 1993. So when she sat down at her kitchen table and offered to put the house in Diane's name just to make life easier later on, well, it sounded like a wonderful, super responsible plan.
But the actual result of that loving gesture? A $72,000 federal capital gains tax bill. That is the exact invoice Diane was handed when she sold the home in 2026. And actually, when you factor in state taxes, the total hit was over $100,000. This was a completely avoidable expense that literally wiped out a massive chunk of her family's wealth, all simply because they used the wrong piece of paper to transfer the property.
Section 1. The kitchen table mistake. How good intentions lead to tax disasters for adult children.
Okay, so to understand exactly how a simple quitclaim deed turned a loving gift into a total financial disaster for an adult child like Diane, we have to look at how the IRS views property. It all boils down to something called the cost basis. Basically, think of this as the IRS's official bookmark or price tag. And, well, because it's the IRS, you know they never lose a bookmark. When Linda bought her house in 1993 for $170,000, that $170,000 became her cost basis. It's the starting line the IRS uses to calculate future taxes. If the house sells for more than that starting line, the difference is profit, and the government, of course, wants its cut.
But here is the trap. It's called the carryover basis. When your parents gift a home to you while they're still alive, the IRS does not reset that bookmark. They don't care that the home is now worth $650,000. No, they force you, the child, to inherit that original 1993 price tag. So, when Diane went to sell the home, the IRS taxed her on 33 years of her mother's appreciation. They looked at the $650,000 sale price, subtracted that ancient $170,000 basis, and boom, taxed her on $480,000 of profit.
Section 2. The stepped-up basis secret. Internal Revenue Code Section 1014.
Now, there is a massive loophole hidden in the tax code that the system really doesn't want you to know about and is designed entirely to protect your inheritance. Let's just run the math side by side here. In scenario 1, if Diane gets the house while Linda is alive, she triggers that carryover trap. She owes $72,000 to the feds, plus around $36,000 to New Jersey, so over $100,000 gone. But look at scenario 2. If she inherits the home through Linda's estate after her death, her basis steps up to the current fair market value. The IRS literally resets the bookmark to $650,000. So when Diane sells it for $650,000, her profit on paper is zero. Her tax bill drops to absolutely zero. Every single dollar of appreciation over 33 years is wiped clean, totally tax-free.
Moving right along to Section 3. The truth about probate costs. Paying $4 to save $1.
You might be wondering, why do parents fall into this trap in the first place? Well, it comes down to a wildly exaggerated fear of the probate process. Your parents are probably terrified of probate. I mean, overly dramatic late-night TV lawyers have basically convinced them it'll eat their house alive. But the fear is way worse than the reality. Yes, probate costs money. In New Jersey, the absolute worst-case scenario for an estate like Linda's is around $15,000 in legal and administrative fees. But giving away the house just to avoid a $15,000 probate process mathematically ruins you. It triggers a $72,000 federal tax penalty. You are effectively paying a massive tax bomb just to avoid a court process that is vastly cheaper.
And what's truly fascinating here is that this math applies everywhere. It doesn't matter where your parents live, the tax penalty of gifting always brutally outweighs the cost of probate. For example, in Florida, probate might be around $5,000, but the federal tax hit is still $72,000. Or in California, where probate is super expensive, like up to $36,000, the combined state and federal tax hit of gifting is a staggering $125,000. It's crazy. You're literally paying $4 in taxes to save $1 in probate fees. It is, quite frankly, financial self-mutilation.
Oh, and please, tell your parents to stop gifting assets out of fear of the death tax. People hear about estate taxes on the news all the time and they just panic. But listen to this. The 2025 federal estate tax exemption is $15 million per individual. Okay? So unless your parents are sitting on an estate worth over $15 million, the federal estate tax simply does not apply to them. They really should not be destroying their cost basis over a phantom tax.
Section 4. Solution 1. Revocable living trusts, the gold standard for home transfers.
So how do we fix this, right? How do we as adult children ensure our parents' assets are actually protected? Well, the absolute best legal tool you can bring up with your parents today is the revocable living trust. Here is exactly how it works. Your parents create the trust and retitle the home into its name. And because it's revocable, they keep total control. They live there, they pay the taxes, they can even change their minds later. But when they pass away, that's when the magic happens. The house skips probate entirely because it's already in the trust. And because it was still part of their estate when they died, you get that sweet, tax-free stepped-up basis under Section 1014. So you win on both fronts.
Now, yes, setting up a trust absolutely does cost money up front. A competent estate attorney is going to charge somewhere between $1,500 and $5,000 to set it up. But just think about this return on investment for a second. Paying $5,000 to avoid a combined tax bill of over $100,000? That gives your family an incredible 2,000% ROI. There is literally no stock or cryptocurrency on earth that guarantees that kind of return. It is hands down the single best investment your parents can make for your future.
Section 5. Solution 2. Life estate deeds, the affordable alternative.
Now, if a full trust feels like just way too much money or hassle for your parents right now, don't worry. There's a very powerful and much cheaper second option you can discuss with them. It's called a life estate deed. For about $500 to $800, your parents can transfer the property deed to you, but they legally retain a life estate. This guarantees that they have the absolute legal right to live and control the property for the rest of their lives. And here's the genius part of this. Because they retain that life estate, the IRS treats the home as part of their estate when they pass, which means, you guessed it, you still inherit the house with the stepped-up basis, giving you zero capital gains tax.
However, as an adult child helping facilitate this, you really need to gently warn them about a few limitations. First off, once this deed is filed, they can't just decide to sell the house later without your legal consent and signature. Second, it only covers the house. It doesn't avoid probate for their bank accounts or anything else. And third, if they need to go into a nursing home and apply for Medicaid within 5 years of signing this deed, it can create some pretty major complications due to Medicaid's strict 5-year look-back period. So just keep that in mind.
Section 6. Protecting your family's future. Your action plan for this week.
Okay, we've covered the trap, the step-up secret, and the solutions. So here is exactly what you need to do this week to ensure you don't become the next Diane, just handing over your family's hard-earned wealth to the IRS. Seriously, take a screenshot of this checklist right now. First, intervene immediately if your parents are talking about signing a quitclaim deed to quote-unquote make things easier. Stop them in their tracks. Second, get an actual estate planning attorney on the phone, not a general practice lawyer, an estate planner. Third, ask that attorney specifically about revocable living trusts and life estates. And finally, if your parents have already transferred the deed to you, do not panic, but you got to act fast. Get legal help to see if you can reverse or rescind that deed before they pass away. I want to leave you with this final thought today. The cost of silence is simply too high. Section 1014 is arguably the most powerful wealth preservation tool available to middle-class families. But it only works if you don't give the house away too early. One awkward conversation at the kitchen table today could literally save your family hundreds of thousands of dollars. So, the real question is, when are you going to ask them?